Today we have Deputy District Judge Rhea of Queen Square Chambers, who will be talking to us about COVID and judicial tech. So to start off with, if you can tell us a little bit about yourself, your journey to the bar, and your journey to sitting as a judge now.
Yes, hello everybody, and thank you very much indeed for coming to this seminar this evening. And I know it's not involving any travel, but it still means you have to devote your time to sit and listening to little old me. I am a person who has in the past no family or legal connections whatsoever. And I knew from when I was very, very young I wanted to be a barrister. I don't know why. I was about 7 and I was tracing diagrams and pictures of wigs and pink ribbons. And I knew I wanted to sit in a dusty old library. But I got to about 15, 16 and I decided, no, I didn't want to do that anymore. It was far too boring. I wanted to go to lots of parties and enjoy myself. So I thought I would go off and do something completely different, which I eventually did. At the age of 18, I went off to train as a nurse at St Thomas's Hospital in London, where I qualified 3 years later, during which time, I won't go into it, I could write a book about it, but I decided firmly on day 2 of that particular expedition that the law was actually the right thing for me and I was in the wrong career. So without haste after qualifying as a nurse, I went off to start my law degree, called to the bar, and then worked as a barrister. The rest is history. I was called to the bar in Don't Faint 1980, and I became a deputy district judge in 1999. So I've been doing that for about 20 years. I've been doing the bar for about 40 years. And initially, as you probably imagine, I started with medical negligence work and personal injury work, as well as, of course, like everybody else, all the rest, including crime and everything. And it sort of emerged that I've come into regulatory law nowadays. For the last 10 or 15 years, I do just that. I advise the healthcare and financial regulatory bodies on fitness to practice. So that's in a nutshell me, and we'll move on because I'm going to start. Can I say straight away that at the end of this, I firmly recommend that you contact Queen Mary Bar Society for the crib sheet for tonight, okay? It's got, it's very short, it's very sweet, and it's got 18 cases and their citations on it. And these are the 18 I am now going to romp through. And then I'm going to finish off with what has happened to me since March as a judge in court. So that's the structure, and I'll kick off straight away with the cases. Now, they start in March and they culminate just last week. So really interesting, particularly last week's one, but you've got to wait for that for a little while because I'm going to start with the March one. And that's the earliest possible one. It's the case of the National Bank of Kazakhstan against the Bank of New York Mellon, and that's a London branch of that. And that was on the 19th of March 2020. And it was the first virtual commercial court hearing. Essentially, they call this anybody who goes to court to argue COVID, and when you get to court, even next year or whenever you do, it will be perhaps not a place yet where we have a vaccine and we can all resume normal practice. So you may be having some COVID aligned arguments, and this will be one of the first cases that is in the action pack for arguing one way or the other on a COVID remote hearing situation. It's called Kazakhstan for short. And it involved declarations as to the banking relationship between the claimant and the defendants, the freezing of the Bank of Kazakhstan's assets by the defendant bank, the New York Bank. And there, the court said, courts exist to resolve disputes, and the guidance given by the Lord Chief Justice is very clear. The default position now in all jurisdictions must be that a hearing should be conducted with more than one, or all participants attending remotely. It seems to me, said the judge, that having regard to the need to keep the service of public resolution of disputes going, it is incumbent on the parties to seek to arrange a remote hearing if at all possible. So that was very firm early on, way back in March when we were all in first lockdown at the very beginning. There followed then quickly on the 26th of March in the Commercial Court an important case also of Reed-Smith Technologies. This was an application to adjourn which was rejected. In short, the judge said there, I do not see that location and self-isolation should in principle lead to communication problems. I take the view that instructions can be taken without anyone hearing them during the trial using mute on Skype and mobile phones, either directly or through apps, and then visual communication can be maintained. The judge went on to say, while self-isolation and vulnerability are of course important, the whole reason for remote hearings is to achieve self-isolation and protection. Remote hearings as such should not present a problem. And there was a reference to poor internet connection that could be overcome with the help of solicitors or short-term renegotiation of your internet server and router to a better system. And it made it clear in that case, justice delayed is justice denied. And this is repeated oft in all the cases we're going to hear today. There then followed a really important document of the 3rd of April 2020, which is not on your sheets. It is the Remote Access Family Court. The author is Mr. Justice MacDonald, a High Court family judge. It is 49 pages long and has 7 chapters. It is War and Peace. It changes minutely, never mind hourly or daily. And whenever you come to deal with family law cases, which you might think are extra special because of the vulnerability in particular of children, you need to bear in mind the ethos of this and framework of this document, which I'm not going to go into, or we would be here until Christmas 2022, I assure you. The President of the Family Division, Lord Justice McFarlane, you've got MacDonald, McFarlane, there's a great Mc thing going on with the family division, it seems to me, a lot of Scottish influence, I think. Anyway, Lord Justice McFarlane, the President, said this in the foreword to the document. Can I stress that we must not lose sight of our primary purpose as a family justice system, which is to enable courts to deal with cases justly, having regard to the welfare issues involved, the overriding objective, part of which is to ensure that the parties are on an equal footing. In pushing forward to achieve remote hearings, this must not be at the expense of a just and fair, or fair and just process. Really important there. So go for it, go for remote hearings, but please do not sacrifice justice and fairness to all parties. The next case was on the 6th of April 2020 and is another leading case in the pack. As Kazakhstan and this one. This is called One Blackfriars Limited against many others. Essentially, the applicants had brought a claim against the former administrators of a company claiming over £250 million for their alleged mishandling of the administration. A 5-week trial of the claim was due to begin in early June 2020, so we're looking at April here, so a couple of months after this application, involving witnesses of fact and expert witnesses. The application to adjourn that 5-week hearing was refused. The legislation and guidance from the courts in dealing with the crisis made it clear that as many hearings as possible should be conducted remotely through the use of technology. The parties were ordered to explore the technological options available to facilitate a remote trial. This was a Chancery Division case. And the court in that case went on to say a number of other things which are important. There was no detailed evidence before the court of the particular difficulties that participants might have in taking part in the trial and how those could be mitigated. And furthermore, the technological challenges of conducting a remote trial were not so great as to warrant an adjournment, it was found. The allegations against the former administrators dated back to 2011, so it was an old case. and any further delays in the case were in neither side's interests. Nor was case one, it was essential to have everybody in the same physical space, and we'll go back to that. It's a revisiting factor in all these cases, the physicality of the hearing. The application was accordingly refused, and the parties were ordered to continue to prepare for trial and try and sort themselves out remotely by technology. One Blackfriars said a couple of other important things in the judgment. The judge said, "It seems to me very clear that by making specific exemptions in this way, that is to say the COVID exemptions, to the two major restrictions on gatherings and on movement for the benefit of the court proceedings, the legislature is sending a very clear message that it expects the court to continue to function so far as they are able to do so safely by means of the increased use of technology to facilitate remote trials." And on to say, looking at legislation and guidance, as many, quote, "as many hearings as possible should continue, and they should do so remotely as long as that can be done safely. A remote trial must not endanger the health of anyone involved, but this trial, Blackfriars, could be prepared safely without doing so. Remote trials had by then been successfully conducted in the Court of Protection and in the Business and Property Division of the High Court. The challenges would apply to both sides equally, and so there was no unfairness, it was held, and it was not essential to have the witness, judge, and cross-examiner in the same room. No allegations of dishonesty or fraud were made, and the matters turned on contemporaneous records amounting to over 25 lever arch files. Lots of evidence. Now we'll come back to dishonesty and fraud, and we'll come back to people, judges, witnesses and the like being in the same room a little later, and I'll give you my own experience of all of that. Next case was on the 24th of April 2020, repeat a child remote hearing 2020. This was adjourned for a live hearing. The case in question, again family, so sensitive, was on the issue of fabricated or induced illnesses. And the issue is whether the final hearing should proceed remotely. The mother opposed the local authority care plan. It was listed for a 15-day hearing addressing whether she had harmed her 7-year-old daughter. Despite the coronavirus pandemic, both the father and the local authority supported the hearing continuing remotely. The mother's solicitors had assumed it would proceed with plans to take instructions by Zoom or in between each piece of evidence. And there were 3 expert witnesses. Now, again, the president of the family division heard this case and said the following. Gave a number of reasons for his decision to adjourn the final hearing. Some of the circumstances were case specific, and that word will come up again and again because every case has to be adjudicated or judged on its own merits, its own facts. The mother had been taken ill with COVID-19 prior to the final hearing. For this reason, the judge found it wouldn't be proper to ask any representative from the instructing solicitor's firm to sit in a room with her throughout the hearing. And so it resulted in a situation where the only way to hear the case remotely would have been with the mother attending from her own home. That created issues because there was no sensible way, they found, to ensure that she could provide contemporaneous instructions to those representing her throughout the evidence. Lord Justice McFarlane didn't feel that any measures were sufficient to allow her to give continuous updating instructions, and his view was that this would have implications on the fairness of the hearing, and I think one can see that. A lay party, where a lay party attends a remote hearing, they should not simply attend from home, perhaps on their own, but there might be the possibility of going to a neutral venue, such as a local authority building or a court building, and have a representative from their instructing solicitors there within the parameters, but at social safe distancing. Lord Justice McFarlane included within his judgment that a judge, quote, needs to be able to experience the behaviour of the parent who is the focus of the allegations throughout the oral court process. And he didn't have concerns about the ability of the judge to cope with the cross-examination or the evidence, but he felt that there were other factors which inform a judge's view and which are required to be considered to reach a full and fair judgment. Though it is unlikely that Lord Justice Macfarlane anticipated any particular dramatic behaviour from the parties in this case, there was no doubt that the judiciary, he felt, do take inferences from the behaviour of a party during a hearing in a way that they may not be able to fully grasp through a postage stamp sized image that we're currently seeing before us now. That every case depends on the specific circumstances of it, of course, the issue being contested, local facilities, available technology, characteristics of individuals involved, the experience of the judge. Not all contested hearings, it was held, should be adjourned. Lord Justice Macfarlane noted that the often conflicting issues to consider are the need to avoid delay for the child, the need for conclusion or finality for the child, the need for a forensically sound, fair, just and proportionate resolution of the matter. And these must be all carefully balanced with the issues of fairness for parties participating remotely. Matters always for judicial discretion. And I have exercised that myself, not in family law, but in other matters, which I'll tell you about later. The next leading case is, again given the nickname, the Mariana. It's the Municipio de Mariana and others, I'm now going all Spanish, against the BHP group and others. The proceedings here arose from the collapse of a dam in Brazil, which had a commercial court case, which had released large quantities of toxic materials and contaminated water. There were over, you wait, 200,000 claimants in this litigation, this case, and the claims were made under Brazilian law. Other proceedings had been commenced in Brazil, and a foundation had been established to provide compensation on a non-litigious basis. But this was an application by the first defendant English company and the seventh defendant Australian company, challenging the English court's jurisdiction and for the claim to be struck out or stayed. And it was listed for a hearing in June 2020. Both sides had served expert reports with substantial exhibits. The defendants applied to extend time for service of their reply to the claimant's evidence by 5 or 6 weeks, which would have meant that the matter in June would have had to have been vacated. Now, that magic word, as soon-to-be young barristers, the word vacating a trial, the word vacating a trial window, will bring to any judge, whatever rank, whatever seniority, wherever they come from, whatever division of whatever court, a tingling of the spine. And I can assure all advocates that they will be given a very, very hard time by any and all judges if they are trying to vacate a trial hearing or a trial window. So, in this case, it was held the starting point was the overriding objective, with the requirements that cases were needed to be dealt with justly. They had to be proportionate to the amounts of money involved, proportionate to the importance of the case and the complexity of the issues, and they must be dealt with expeditiously and fairly. The court had to, under the new Practice Direction 51ZA, paragraph 4, of the White Book, the rules of the Supreme Court, is the CPR. The court has to take into account the impact of the Corona-19 pandemic as far as compatible with the proper administration of justice. In light of the authorities since the start of the pandemic, the following principles governed whether a particular hearing should be adjourned if a case could not be heard face-to-face, or whether instead there should be a remote hearing. And this comes from Kazakhstan, Smith and Blackfriars. So already we've got case law rolling into this, and the Mariana completes that little number of cases that are considered leading cases on this, One, regard was to be had to the importance of the continued administration of justice. Justice delayed was justice denied, even when the delay resulted from a response to the prevailing circumstances, COVID. There was to be a recognition of the extent to which disputes could in fact be resolved fairly by way of remote hearings. And we'll come back to that too. The courts had to be prepared to hold remote hearings in circumstances where it would have been inconceivable only weeks earlier, and that is so true. There had to be rigorous examination of the possibility of a remote hearing and the ways in which such a hearing can be achieved consistent with justice before the court should accept that a just determination could not be achieved with a remote hearing. Whether there could be a fair resolution by way of a remote hearing would be case specific, and a multiplicity of factors would come into play, and the issue of whether or what, to what extent live evidence and cross-examination would be necessary, which we'll come back to again, was likely to be important in many cases. There would be cases where the court could not be satisfied that a fair resolution could be achieved by way of a remote hearing. Moving swiftly on, now we come to the 23rd of April 2020. Some of the reports have come out on the 11th of May of this one. Be a child remote hearing interim care order. This was appealed by a grandmother, which was allowed for the hearing not to be remote. It was a 9-year-old boy removed from the grandmother's care into foster care. And the final resolution was that it was going to have to be a live hearing, and it was adjourned. The fundamental principles, it said, of substantive law and procedural fairness are unchanged. A remote hearing, where it is appropriate, can replicate some but not all of the characteristics of a fully attended hearing. And the court said we must be alert to ensure that the dynamics, and that's a really good word, and demands of the remote process do not impinge upon the fundamental principles. In particular, experience shows that remote hearings place additional and in some cases considerable burdens on participants. Moving on now to May, we're getting there. Re-A Children, Remote Hearing Care and Placement Orders 2020. This was the first case in the Court of Appeal on remote hearings, and Re-P was followed. It was adjourned for a live hearing. It was due to be a 5-day trial in Carlisle with expert evidence. It said, any decision to hold a remote hearing, and by what means, is a case management decision to be exercised by the tribunal hearing the matter, so the judge. As with all case management decisions, the court of first instance will be afforded a wide discretion based on the, quote, ordinary principles of fairness, justice, and the need to promote the welfare of the child. And that's, of course, the absolute bottom line of all Children Act cases. Therefore, an appeal will likely only succeed where the decision is deemed to be an unreasonable way of proceeding and therefore likely to be wrong. Any guidance issued by the senior judiciary is simply that. The aim is to support the tribunal in its decision as to whether a hearing should proceed remotely or not. And moving on to the 5th of May, this was coming in cascades at this time, as you can imagine. A local authority against 1, a mother, 2, a father, and 3, SX by his children's guardian. In this case, the proceedings concerned a 4-year-old boy whose parents were accused of causing fatal injuries to the boy's infant sister. And it was appropriate, it was held, having considered the factors in A, the one we've just looked at, to conduct a remote hearing by video link to hear the parents' evidence and not to adjourn the matter. It was said, amongst other things, I won't go into detail on the case, eliciting the truth in remote hearings. An important factor in deciding whether to proceed with remote hearing, particularly in fact-finding cases, was whether the judge would be in a less good position to judge whether the witnesses were telling the truth. It was fairly common for vulnerable lay witnesses of fact to give evidence remotely by video link, and that's very, as you probably may guess, very frequent, not just in children cases but also in crime and in all sorts of other cases. It followed that the giving of evidence in that way did not undermine the fairness of the process for either the individual concerned or the other parties. One reason vulnerable witnesses often gave evidence remotely was to protect them from the stresses of the court. However, it might also be the case that a vulnerable witness was more likely to give truthful and complete evidence if allowed to give it remotely. So the benefit was not just to the witness, but also to the judicial process. It was not possible, said the court in that case, and we will come back to that, to say whether it was easier to tell whether a witness was telling the truth in court rather than remotely. I'm coming back in spades on that one. And then re-cue a child comes next. That was the 6th of May 2020. A judge, it was held in short, had erred in deciding to vacate a remote final hearing concerning the welfare of this child 2 days after deciding that the remote hearing was appropriate. Nothing had changed in the judge's original findings, that there had to be finality for the child who was suffering emotional harm. So it very much highlights wanting that finality and needing that. On the 13th of May 2020, which is not on your sheet because it comes from the Lord Chief Justice, a short quote where we call it no going back quote. Lord Burnett of Malden said this to the Law Society in the Law Society Gazette, a very important matter. There will be no going back to where we were. We had to deal with this from the second week of March onwards, and there will be no going back to February 2020 in the courts. Of that, I am confident. It seems to me that we have, by necessity, taken 3 steps forward and done so using poor technology. We will probably take steps back once the pandemic ends. Lord Burnett said that the rapid changes in how courts operate had highlighted the underinvestment in the system for years prior to the lockdown. That has changed in recent years with money spent on modernisation, but there have been question marks about whether further funds will be allocated to complete the programme. Will it take a COVID pandemic of this ilk, I wonder, to jettison those in charge of the purse strings to make sure that we have proper and fair justice? The next case was the 4th of June 2020, and so we're nearly there. SC, a child suing by her mother and litigation friend against University Hospital Southampton NHS Foundation Trust, a clinical negligence case. And this was a case where a child, now 15, had been admitted to hospital with a high temperature when she was 15 months old. She was discharged before being readmitted, and meningitis was diagnosed. She subsequently developed hemiplegic cerebral palsy. Number of issues were going to be raised there. The trial had been listed for January 2020, but it was adjourned because of the ill health of one of the claimant's expert witnesses and relisted for the 8th of June 2020. And the application was made on the 28th of May 2020, the judgment given on the 4th of June. A remote hearing was the default form of trial during the COVID pandemic. It was ordered, in short, that the case was fully prepared for trial. The hearing took place, was ordered to take place within 1 week of that judgment remotely. So there you are. That shows the robustness of the courts, particularly in non-family matters, non-children matters. Then we come to the 16th of June, Ries, a vulnerable parent intermediary. This was, in short, a judge had erred, it had made a mistake in refusing an application in care proceedings concerning a child for an intermediary assessment and the appointment of an intermediary to support the child's mother who had learning difficulties. The final hearing was to be conducted as a semi-remote or hybrid hearing, which I'll come back to, because of the COVID-19 pandemic, and the judge had failed to sufficiently address the additional factors to which a hearing would give rise, and those factors we're going to come to now. This is one of the most important cases that came about on the 18th of June 2020, Lancashire County Council against 1 mother, 2 father, 3 C, a child, by the child's guardian. In short, this was in Lancashire, it was care proceedings, allegation of physical harm from both parents against a 21-month-old child. This was ultimately not adjourned for a live hearing. It was, they pressed on and were ordered to press on with what was going to be a hybrid hearing. But in that case, important factors where Mr. Justice MacDonald, the author of that family paper of 49 pages, said this a lot. So bear with me, I'm going to take most of it. The following factors should be borne in mind, whether or not to have a remote hearing, a hybrid hearing, or a live face-to-face hearing. The welfare of the child, of course, that's paramount. The delay in determining the question was likely to prejudice the welfare of the child. The requirement to deal with cases justly having regard to the welfare issues involved. The extent to which a remote or hybrid hearing would provide the judge with a proper basis on which to make a full judgment. What steps could be taken to reduce the potential for unfairness by enabling the case to proceed fairly when previously it may have been adjourned, having regard in particular to the need to make every effort to accommodate and enhance the ability of the lay parties to engage fully in the remote or hybrid process. The impact of COVID-19 on the likely timescales of a full face-to-face hearing, and that's the problem. If you adjourn out because of COVID, you might be adjourning for very, very much longer than perhaps you would have done pre-COVID. The statutory requirement that all public law children cases were to be completed within 26 weeks, and there had to be a good reason for extending that. The requirement, so far as practicable, to allot the case an appropriate share of the court's resources. I mean, this judge has thought of everything. The court's resources, really important, comes up in the CPR all the time. The courts have limited resources, we all know that, and so that has to be also borne in mind. The individual circumstances of the case and the parties, but not limited to whether the parties consented to or opposed a remote hearing. The importance and nature of the issue to be determined, whether there was a special need for urgency, or whether the decision could wait for a later hearing without causing significant disadvantage to the child or to the other parties, whether the parties were legally represented, the ability or otherwise of any lay party to engage with or follow remote proceedings meaningfully, whether evidence was to be heard or whether the case would proceed on the basis of submissions only. That's again another factor that comes up time and again. The source of any evidence that was to be adduced and assimilated by the court, the scope and scale of the proposed hearing, the available technology, the experience and confidence of the court and those appearing before the court in the conduct of remote hearings using that technology. I mean, at the beginning in March, it was something else when I went to court. Well, I eventually went to court in June because it took so long for them to get us going. Any COVID-safe alternatives that might be available for some or all participants to take part in the court hearing by physical attendance in a courtroom before the judge, and any other factors idiosyncratic to the particular case. Other factors that were case-specific, and it was clear, it was held from the signpost set out in the family court and in the document produced by this judge, that adjourning cases indefinitely or for many months would not be a viable option, and adjourning a case to await a fully face-to-face hearing was unlikely to be the proper course where an effective and remote and fair remote or hybrid hearing could be held with steps taken to maximize fairness and prevent unfairness. So that is a very important case indeed, because it really details the fine points that have to be taken into account when you are arguing before a judge, and the judge, him or herself, has to take into account when deciding whether or not to adjourn. And then finally, the 16th of October 2020, what's that, 2-3 weeks ago? The overwhelming case, it is only a Chancery Division first instance case, but it has had repercussions. Lucas against Gatward and another. And you'll see that is the last case on the list when you get it. This was a claimant's application to vacate a trial the Chancery Division case, due to her and other parties or witnesses being vulnerable and unable to attend court during the coronavirus pandemic. The application was refused. Those parties unable to attend would give evidence via video link. And the court said this, hold your breath. Giving evidence via video link did not undermine proceedings, as seeing a person's demeanour in person was not a good guide to truthfulness. Help! That's everything, that goes against everything that might have been hinted at or said thus far. In fact, in that case, the costs at this preliminary stage were, claimant's costs were, it was basically, in short, a family dispute on property ownership. The claimant alleged she had a 1/3 beneficial interest in a property that her mother had gifted to her brother under constructive trust or by proprietary estoppel. And she alleged her parents had given her assurances that she would have an interest in the property and that she had acted detrimentally to her financial detriment on those assurances. And the mother denied the allegation. The property was valued at £2.65 to £3 million. The costs to the date of this application, 16th of October, were for the claimant £300,000 so far, and for the first defendant £500,000 so far. So perhaps you can see why the court said, well, let's get on with it. But the court did say, and it's been quoted very often on various websites and in the legal world, those words, seeing a person's demeanour in person was not a good guide to truthfulness. Wow. Well, let me tell you now, finish with the law. Let's get on to the fun for the last bit of my speech to you. Okay, telephone first. So I went into court round about June. They got the deputy, the full-time judges were in a little earlier doing telephone hearings primarily, and then they got us all a bit more savvy about the other methods, the other platforms. And so at first I came upon the telephone, and the court system, I think, went out to a marketplace and bid for this thing. I don't know. It's called BT Meet Me, and it is not good. All right. It was cumbersome. It was clunky. In the smaller courts, I mean, some of the courts I sit in are rural, but other of the courts, be they London or in elsewhere, are small courts, tiny courts with no staff or very little staff there, particularly, of course, in COVID with the vulnerabilities and the furloughing and all the rest of it. So a lot of those small courts, I'd get to court without any previous warning and be told, well, the phone numbers you want are in the file. Now, I don't know if you've seen court files. They certainly bear no resemblance to trial bundles, I can tell you that, which is why we judges need trial bundles when we have hearings or trials. But the court file, it's like somebody's taken a pack of cards and just shuffled them, you know? No date order, no rhyme or reason. You just get in and you spend half an hour sorting out almost every single file. And in the middle of all this, I had to then extrapolate all the phone numbers of various parties, not just the claimant and defendant, but also counsel and witnesses and solicitors and Uncle Tom Cobley and all. It was absolutely exhausting, far more tiring than a normal pre-COVID day. I was told by some barristers appearing before me that the platform called Kidatu, K-I-D-A-T-U, was a really good platform, but it cost the parties money. But was apparently well worth the money and much better. So there's no cutting off, which is what happened on BT Meet Me all the time. Be cutting off, and then you have to go back, re-telephone, and there was a very complicated procedure for getting them all on the telephone, which involved a lot of hashing, a lot of starring, a lot of different other numbers, as well as the phone numbers and all the rest. I can't even begin to tell you. I don't even really know. I have to have a kind of laminated card before me when I do it, even now. The other way of telephone calls was the teleconferencing that we always use. We often have telephone conferencing calls for case management hearings and the like. That went very well because that's organised by the staff who are in the back room, and they then just put the call through. These telephone BT Meet Me type calls were used for all sorts of different types of hearings that I had. the first directioned appointment in family law, FDAs as they're called, and family dispute resolution, FDRs. Now, the FDAs are basically everybody gathering together and finding out the whites of the eyes of the other party. Fine, and that's very, very at the very beginning of divorce proceedings and not a problem. But the FDR is a more serious matter. It's tantamount to mediation. Every party, under penalty of goodness knows what, has to attend with their lawyers, and they have to be there 1 hour before in order to engage in active and positive mediation with a view to resolving the case, so it does not have to go to final hearing. The argument being we're trying to save divorcing couples a lot of money, and it makes huge, huge sense. Those were much more difficult on telephone hearings, and many of them came through phone hearings, you can imagine, because they normally have to go out into breakout rooms outside and discuss matters between themselves, and then with the opposite number, and then they come in and see the judge. One day I had a disputed road traffic accident matter on the telephone, not BT Meet Me, it was on the telephone conference. And you know what, it was surprising. I found it not too difficult at all to be able to assess and adjudicate on the credibility and honesty between the claimant and the defendant, such as to decide who had turned the wrong way and who had not. So it was surprisingly easy. I was astonished. I went with some degree of skepticism, and I was quite gloomy before the case started. But by the time I came off the phone, I thought, well, that was a real lesson. Something I would never have imagined in a month of Sundays. On another day, I had two small claim track road traffic act cases, each 2 hours long by telephone. One was actually a road traffic one, and the other was about a faulty roof, and that was dealt with on the telephone successfully. On another day, I had 8 cases, all BT Meet Me, 2 return of good applications, 2 divorce applications, 1 occupation order, which is injunction work, a possession application, a costs application, an antisocial behaviour order on directions, each of them between 10 minutes and 1 hour long. I did have no lunch that day, and that was all on the telephone. On another day, I had 4 Family Law Act applications. They were 30 minutes long on the telephone, in a 2-hour application to set aside judgment by telephone, and another Family Law application by cloud video platform, which I'll come to in a minute, CVP. So you've heard I've done a lot of different mixed ways of dealing with things. I had 1 fast track of 3 hours on Microsoft Teams with 2 hours reading required. I attended court at 9 AM, realised there was a huge amount of work to be done on the case. And then there was also another directions hearing in the list on the telephone. The first case, the Teams one, had enormous complexities and reading, as I say, for a long time. The case was listed for 30 minutes, but in fact it went to much longer than that. It involved a dispute between the owners and sellers of an inflatable rib boat. The boat was worth £10 million. 2 counts were involved, and it concerned the total destruction by fire of the said rib boat at the time of sale, when it was unclear as to the insurance position of that boat and if the new owner was in fact the owner or a mere bailee. In the end, I was able to mediate them to a resolution. Don't ask me how, I can't remember now, but it was a very interesting case at the time. And again, I had no lunch, and I also, I think, probably had a raised blood pressure on that day. Moving on, if I may, then to video hearings, CVP and Skype for Business. That is what is the default position of the Courts and Tribunals Service, HMCTS. Has to be Skype for Business, it has to be CVP. I've done many lists using CVP, including credit hire cases, road traffic accident cases, service charge disputes in rented premises, housing or property law, and on the Blitz court. Now, some of you may know what this means. In the summer, indeed Easter and Christmas as well, but particularly the summer, the Southeast London County Courts get together and comprise of a Blitz summer. So you go in for 8 or 10 weeks and you have all sorts of different deputy judges who come in, some full-time judges who come in during the summer break, and it's always a joy because, of course, pre-COVID, everybody would be out of London in August, and so getting to work was much better. And this was a blitz list where we'd be doing the overflow work, where there'd been massive backlogs of all the courts around the southeastern circuit. And the blitz list this summer, which I did remotely, I was physically in the Royal Courts of Justice, because it's always held in the Royal Courts of Justice for 8 to 10 weeks, July, August, and part of September. So that I was sitting in the courtroom in the High Court with my camera on, with my screen, just as I am with you, and doing all these various overflow cases, a lot of them road traffic accident, as I say, and credit hire and the like. So we use CVP for that. Some of the time we use Skype for Business. Both are very efficient. The CVP isn't as good because it's a court recommended platform, and again they went out to the marketplace and they didn't get necessarily the most efficient one, but it's catching up. Unlike Skype for Business, at the beginning CVP didn't have rooms you could go to break out, so parties could take instruction, give instruction, speak to each other, come back into the room. The judge, I could go to my chambers and prepare a judgment at leisure. Because they didn't have that facility. So I would literally have to say, well, I'm going to sit here now and be silent while you sit and stare at me while I think about the case, which was not comfortable and not easy to do, and I did not enjoy it. So it's much better to be able to go away by making the screen disappear and come back again when we were coming back in, making it go mute and so on, and then telling parties come back in half an hour and 20 minutes or whatever when I will give my judgment. So that is the ideal way, and that's the way I enjoy on Skype and CVP. Finally, hybrid hearings. I did one of these one day quite recently. I've done a number of them, and this involves one part of the hearing people, whether claimant, defendant, witnesses, whoever, barristers, at home on remote, and the other part being in court with the judge, and there being a big screen up in the courtroom that should work magically to bring everybody together. Well, I did this case, and I've got to go into a little detail with you because it's very funny. The claimant was a carpenter who was walking around the construction site at the time of this employer's liability accident. He claimed that the defendant, a construction builder and driving his lorry at the time, had run him over in the defendant's lorry without warning and for no apparent reason, fracturing the claimant's pelvis, i.e. he ran over his pelvis. The defendant contended that the claimant was author of his own misfortune by playing games and mucking around, and he jumped up on the side of his lorry, stuck his head through the window, fell off the lorry and was run over by the defendant, who couldn't avoid doing so as it all happened so quickly. The case, as you can imagine, centred around the credibility of both the claimant and the defendant, who were the only, well, at that stage were the only witnesses. We later learned there were others. It concerned the fractured pelvis of the claimant, and it emerged that the value of the claim of general damages for pain, suffering and loss of immunity alone were £15,000, so it was a serious case. The defendant was on CVP video link, and his counsel was on a separate screen on CVP video link. The claimant and his counsel were live in the courtroom, where I was live with them. As I commenced the case, it was clear to me that things were not progressing satisfactorily, as follows. The defendant's face was hidden by his label, and his picture was too small to be seen by the claimant. So not only was his face, but actually the picture was too small by the claimant's counsel, his own counsel, who was also on CVP, or me. Therefore, his expressions could not be seen. The defence counsel said he couldn't see the full courtroom on his screen, as the courtroom camera was not able to be positioned so that he could even see the witness box. So when The claimant went into the to be cross-examined by defence counsel who was remote and claimant was live in the witness box. That would have served no purpose whatsoever for the poor defence counsel who couldn't see that far ahead because it was a tiny speck in the distance. Two further claimant witnesses were scheduled to join the hearing remotely by CVP partway through and give evidence on the accident itself and his injuries, the claimant's injuries, but it hadn't, I'm afraid, been anticipated by the court. And there were no technical means to set this up, and certainly not me as host, as I am called on the CVP platform. Excuse me. There was no way on CVP for the parties to break out. So for Teams, on Teams you can, it's marvellous. Got rooms you can go into, private rooms in and out all the time, and it's a very, very good way. But apparently the court system didn't like the way Microsoft was unable to guarantee confidentiality at the very beginning back in March. I think that may have changed now, because I have seen a few hearings and have had myself a few Teams hearings. So they can't discuss with each other, claimant and their counsel, defendant and their counsel, how the trial is progressing, as we've heard from some of the case law. There was considerable volume feedback on my own microphone on that day, and this stopped as soon as I stopped the hearing. So I knew it was not a problem with my personal computer. I felt that also by proceeding with the hybrid hearing, the claimant would have been advantaged and the defendant disadvantaged to continue, and all the parties agreed. So I adjourned to a full live hearing and giving full, robust reasons. So that would have been sometime down the line. Just a few miscellaneous points, if I may. Bundles and security. This is not detailed advice. You're often asked by your solicitors or by others to ask the judge whether the judge prefers paper bundles or e-bundles. Just as an aside, Adobe Acrobat and PDF Expert are the two best systems because they allow, excuse me, for annotation and redacting of bundles. Be alert as to your GDPR requirements when handling bundles. I'm sorry, I've been talking for so long. Have you got documented systems in place for GDPR and Data Protection Act 2018 compliance as an individual barrister? If not, go to the Information Commission Officer's website, the BSB, the Bar Council's website for full information. Are your smartphones, iPads, computers, laptops and so on, are they all encrypted? Is your email encrypted? Are your documents safe? Are you registered, or are you going to need to register as a processor or even a controller or joint controller with the Information Commissioner's Office when you start practicing? If you do not do so and you're meant to do so, the penalty can result in disbarment. So please be very aware of your duties and go to the ICO's website if you're in any difficulty. Finally, Perspex screens have been popped up in courts all over the country, and QR codes for COVID security. We always know this, an announcement at the beginning of the hearing that although all hearings are open and in public, save of course for Children Act and other specific cases, we say this is an open hearing, but no recording, if it's remote, can be made by anybody of the hearing, save and except of course cases like what we're my speech here today. Future trends. The immigration tribunals literally last week have expressed reservations about remote hearings, as the parties involved usually are vulnerable people of limited means and often without English as their first language, and I think we all understand that. The same is happening, as you've seen, the trend in family law cases where there is a move afoot to reinstate legal aid for those affected by these cases, including vulnerable children, and where there's been a trend for remote hearings. We shall see where that goes. On the 30th of September 2020, live possession hearings were resumed again. These have to be formally reactivated. I've been trained on it because I have volunteered myself as one of the judges to be able to hear those hearings. They have to be live, and there has to be very many hoops that various parties have to jump through, including reactivation if they've been stayed back in March. Essentially, they have to be live for this reason. We're looking at vulnerable people, very often who are in the lower income bracket, very often without English again as their first language. They almost always need, particularly those housed in social housing, the duty solicitor. And the duty solicitor can only be available properly and effectively live in court. So these resumed possession hearings are going to be live. We're in second lockdown now. We've had no idea from anybody about whether those live hearings are going ahead, but I suspect they will do with social distancing, although at the moment, until early December at least, we're not supposed to go to work unless we have to. Whether or not that means litigants who are about to be evicted or not, that may be another matter for debate. Do know that I was very surprised, very pleasantly surprised indeed, by having litigants in person, many of them appear before me, as we do in the county court, who are and were extremely tech savvy, much more than the media and other agencies have been making out. Very aware of how to deal with their smartphones, how to deal with their computers, and where they weren't, and they were elderly perhaps, or they didn't have a computer, they would be at home, where I as the judge would give leave for the daughter or the son or whoever it was, the carer, to be in the same room but not speaking, so they could help that vulnerable person deal with the remote hearing. And it's worked time and time again, and very well indeed. There's the issue of reduced travel costs, and there's the issue of less stress when you're giving evidence in your own home. We've heard all of that. One thing in conclusion I would say, that the sharing and the caring that virtual hearings have engendered, in my experience, within society, and that I've seen actively demonstrated, has and remains the best news of all. That something happy and positive can come from this awful pandemic. Thank you all very much.
Thank you. Thank you so much for speaking to us on that, the cases that you have mentioned. There are really just two main questions following on, since you mentioned most of it already. One is that you said that the credibility of witnesses, you were able to assess it well, even by the phone. Could you tell us how that was, how you were able to tell? Is it to do with the tone, or what they were saying?
Yes, that's a very good question. It was not the tone, it was the content, and it was using forensic skills on assessing the evidence before reading, identifying the issues likely to be raised, seeing that questions were asked properly. And in one particular case, well, more than one, they were litigants in person, so very often in those cases, what I do is I stop them from cross-examining, simply because when they ask questions, they usually put their whole case instead of asking proper cross-examination questions. Very hard skill, cross-examination, that you are all training for and will hone when you become pupils. But essentially, I then instead give them a chance to give their side of the story, and the other side their side of the story. And in the process of doing that, I gently cross-examine or act as devil's advocate for each of the two parties. So I forensically analyse all the issues that have occurred to me in advance, and that may have actually come about additionally in the evidence that they give when they're telling their story. And it is purely having gone away, having written down the evidence and saying to them, I'll ring you back in half an hour and I'll give my judgment, gone away and thought about what I've written down that they have said, and then realizing that I can make a very valuable and proper judgment on credibility and the like. So it was just the usual forensic exercise that you couldn't do if you were an inquisitorial system where you were hearing cases based on papers only. So it's a kind of a hybrid where you haven't got them in the courtroom live, you haven't got them on camera, you've got them on a phone, but you haven't got them just on papers. So it works. In extremis, it works.
Yep, thank you for that. The second question is, So the bar is known to be quite traditional in a lot of ways compared to other industries. What has been like some of the biggest challenges in making this switch, and especially as you know it's been locked down and then there's been some release of it and now it's back to lockdown? So you know, what are some of the changes that will happen and the challenges based on it?
I think the question is predicated on, if I may say, a slightly out of date and old fashioned way of dealing with the matter. It is essentially that I have found amongst my own fellow barristers in chambers and amongst my barristers who are deputy district judges and amongst those where I work in the regulatory law field, a very modern profession, a very technological profession, and one that has been able to address absolutely head on all the technology issues thrown at us, including how to deal with the CVP platform, Teams, Zoom, Skype for Business, BT Meet Me, and as I've said, the barristers even came up with another one they'd found called Kidatu, which is even a better telephone medium or platform. So no, I think you will be there too, technologically savvy and with it, and where you're not, go away and learn about it. I had to a lot. We got something on average of about 40 papers a day coming through in March as judges on our e-judiciary emails from people like the family division, the commercial division, the chancery division, the civil division, as to how best to go ahead and to make the cases take place no matter what, because justice delayed is justice denied.
Thank you for that one. So it's true that a lot of people actually, it's more modern than they would think, the bar.
Much more.
Yeah. So I think that's all the extra questions we have. You mentioned trends as well. Just one last one is, what should law students expect, like now, if they're going for like judicial marshalling, if they get those opportunities, what should they expect and be prepared for, what with some of it being virtual?
I think they would probably get the experience that I've described to you this evening, because they'd be sitting marshalling or shadowing a judge with us at the screen, looking at the screen, discussing with the judge that they're marshalling with or shadowing the issues and problems that the judge is having, experiencing them, maybe even hearing a few swear words along the way in the daytime when things don't go right and when the links drop and when microphones have feedback and all the rest of it. So you'll get absolute 100% one-in-one full-on experience, and it will be all the better. It would be wise to go and sit with a judge in court who might be acting remotely with just everybody on screen like yourselves, or might be having a hybrid hearing, which will be partly live and partly CVP or Skype. So it'll be as valuable as if it were no COVID.
Thank you for that. I don't think we have any further questions. If there is, you can put it on the chat. You can email Queen Mary Bar Society directly. Oh, sorry, just one question has come up. So, Aino, sorry. Do you, as a judge, have the final word in deciding which platform to use for a remote sitting?
Yes. Short answer, yes. Absolutely. As you've heard from the case law, you do. If you're a junior judge, maybe, or an inexperienced judge, you maybe dash along the corridor and find a more senior or full-time judge to ask. But generally, we have the measure of it. We know.
Okay, thank you. It's a really interesting talk. Judge Rhea will be back in December for another talk on what law schools do not teach you, judge's perspective on that, and the link for that is there. Again, if you have any questions, you can always email Queen Mary Bar Society directly, but also Judge Rhea is on Judge Rhea is on LinkedIn and her email is available. And I'm sure she'll be okay with anyone emailing her directly. This week, we also have on Wednesday a human rights and public law panel. The link for that is also on the chat. We will have barristers practicing in those areas telling us about their expertise and their experience. So please sign up to that as well. Judge Rhea, if you have anything else to say to finish off.
No, thank you very much. I am completely done, and I hope you've all enjoyed yourselves, and thank you so much, all of you, for coming and attending. It's been lovely to have you all here. I can see names and people. It's wonderful. So thank you, and I'll see some or all of you in December.
Thank you.
Thank you. I'll leave now. Thank you very much. Bye-bye, all of you. Bye-bye.